Okay, fantastic. Good afternoon, everybody, and thank you for joining us today. My name is Folashade Adiema, and I am a lecturer at the University of Reading. Thank you to everybody who has registered and taken time out to join us today for this discussion. I'd also like to say a very big thank you, gracious thank you to the Commercial Law Research Network Nigeria for graciously agreeing to host today's webinar in collaboration with the Global South Dialogue on Economic Crime. The Global South Dialogue Network is an interdisciplinary platform for the advancement of knowledge sharing between Global South countries. It is committed to making innovative and research-oriented responses to address complex economic challenges in the Global South region. The webinar today is the second in a series of webinars on banking regulation in Nigeria. The first webinar launched my book, Banking Regulation in Africa, The Case of Nigeria and Other Emerging Economies. Details on how to purchase this important text will be shared in the chat shortly. Today, you will hear from seasoned practitioners, and I'm really excited with the panel speakers that we have today. They will share their insights on the Banks and Financial Institutions Act 2020. BOFIA 2020 is the latest in a long string of regulatory attempts to bring regulatory oversight to the operations of financial institutions in the country. When it was signed into law in November 2020, it was designed to be the long-awaited strengthener of the regulatory and supervisory framework for the financial industry. So today, we simply ask, what new era has BOFIA 2020 ushered in? Is it simply a case of out with the old and in with the new? 2 years down the line, it is now time to explore whether BOFIA 2020 is indeed living up to its expectations. And I think that will be the main takeaway from today's session. This session will be recorded and it will be made available to the attendees shortly after the conference. I thank you again, once again, for joining. We really appreciate your time, and I will hand over to Bolande.
Thank you very much, Fola. For those who don't know me, my name is Ajibola. I'm an associate professor at the School of Law at the University of Reading, and I convene the Commercial Law Research Network Nigeria, which is better known perhaps by its acronym CLRNN. We're a network established to promote research and knowledge exchange on matters relating to the development and reform of commercial law in emerging economies such as Nigeria. And our goal is to contribute to the design of effective commercial laws in such jurisdictions. And to achieve this goal, we create a collaborative environment in which researchers with expert knowledge, such as Fola, of domestic and international context, can interact with stakeholders who deal with the practicalities and consequences of the reform, such as our panelists today, with a view to collaboratively shaping reform policies. In addition, we create an ecosystem through which high quality research can be facilitated. And we have, for example, been holding a monthly seminar series called Spotlight, which has resulted in several publications, and that focuses on insolvency law. In line with this vision, we held our inaugural stakeholder roundtable, which was co-hosted with the Nigerian Institute of Advanced Legal Studies in Abuja in July this year. And our discussions focused on 4 aspects of commercial law, including insolvency law, new technologies and business, intellectual property law, and international trade and investment law. Following from this event, we have identified key strategic areas for legal development with regulators in those areas in Nigeria. We also held our first conference on insolvency law in Africa, co-hosted with the African Sovereign Debt Justice Network. And we will publish excerpts from the discussions at this conference through our website, www.clrnn.net. We do this on Fridays. We call them CLRNN Fridays, so you should watch out for them. And if you want to be a part of our network or our mailing list, you can write to info@clrnn.net. Well, for today, as you can well imagine, we are delighted to continue our conversations on the development of an effective regulatory framework for the banking and finance sector in Nigeria, which we started at Fola's book launch earlier this year. At that event, we focused on the theoretical and historical underpinnings of the extant system. But today we engage with the practice end of things. And so we have invited speakers from various aspects of practice in the banking and financial regulation space to provide us with real-life perceptions of the new regulatory framework. Before I introduce our first speaker, please, I'd like you to note a few housekeeping rules. Please be reminded that the event will be recorded and uploaded to our YouTube channel. Each speaker has 15 minutes to make their contributions, and I will give a 2-minute warning. We will take questions after all the speakers have made their contributions. Please use the question and answer boxes for questions. The full bio of each speaker will be transmitted via the chat box, and you can also find links to the websites that have been mentioned there also. And with this, I'll move on to introduce our first speaker. Our first speaker is Professor Ajayi, SAN, who is a partner at Olaniwun Ajayi Legal Practitioners. He has almost 4 decades of experience in banking, project finance, capital markets, power, infrastructure, mergers and acquisitions, and several aspects of commercial law. You would find the rest of his bio in the chat, as I said. And with that, I'd like to invite Professor Ajayi to give us his contribution.
Okay. Good afternoon, ladies and gentlemen. And let me begin by thanking our dear ladies, these great experts in the important issue of banking and finance for the great work they do. So in the 15 minutes that have been allotted, I would like to speak very briefly about reflections on BOFIA 2020 from the point of view of what Dr. Ademoyon said in her introductory remarks, whether it is the old out and the new in. In summary, what I think is that it's neither of this. A lot of the old remains, but then you have quite interesting provisions that I think underscore the need for and the pillars for banking regulation. And I think that's what CBN and the legislators set out to achieve with this law. Looking at why you should have banking regulation, the importance of banking regulation, and the pillars for this. And in looking at this, I will just consider very few things of the number of new things that the statute introduces. I remember Mr. Ellinger, a great banker himself, says, in order to safeguard the stability of the banking system, a degree of regulation and supervision needs to be imposed on banks themselves. And I think this is a starting point by which we need to look at this statute. And it does this with 2 key things, a licensing regime and a regime of regulation and supervision of the operations of banks and the activities of banks. The new thing that BOFIA introduces is that with respect to licensing, there is now a more transparent method of evaluating the ability of an entity to observe the banking law and the regulations or the guidelines that are issued to govern banking operations. And I think this is one of the key pillars that the statute seeks to introduce. The second thing is that the license focuses a lot on what happens domestically as opposed to what happens internationally. And I think in the world in which we live, one begins to see the importance of that. Jumping quickly to the question of regulation and supervision, we find that the pillars on which supervision of banks or financial institutions is now based is 3-pronged. The first is to ensure that banks are operated in a prudent manner. The second is to reduce systemic risk. And the third is aimed at implementing a system-wide support-based mechanism. system-wide support-based mechanism. And you begin to see this when you look at the resolution trust provisions of the statute and how that interplays with provisions in the Ancon Act as amended. And in terms of regulation, you find that CBN, looking at the statute, is now more focused on risk-based regulation. And that helps because it makes things a bit more scientific rather than just applying a broad brush to paint every bank. It allows CBN and indeed the market as a whole, especially the banking public, to assess the risk of placing deposits with banks, because that clearly is one of the most important elements of central banking regulation. As we know, what the law seeks to do is to ensure an efficient mobilization of funds, then an efficient deployment of those funds in order to grow the economy, and it uses the various tools it has to do what it is expected to do. In other words, CBN, be A, the bank of last resort, B, also the party responsible for ensuring monetary stability in the country. Leaving aside that part of what Bofia does, let me move quickly to the second thing, which is preventing bank failure in Nigeria. And I think this is where you see most of the new provisions of Bofia. And so, there is a new toolkit for failure of resolution of banks. And this you would find in sections 34 to 42 of the Act, sections 74 to 79 of the Act, 102 to 129, 34 to 42, 74 to 79, and 102 to 109. And let me summarize this with 5 things. One is section 34, which gives the CBN governor a lot more broader powers to make orders that, to deal with the failure of a bank, and in order to ensure financial stability in the system. And that's in section 34. The second thing, revolutionary, are the bailing powers of CBN. And this, it is drawn based on its experience with banking failure in 2007, 2008, 2009. And then, fast forward to the set of banking failures that we then saw in the last 6 years. It doesn't draw on the banking failure of earlier, because that was actually dealt with in a large part by NDIC Act, which had provisions on bridge banking, but didn't go far enough because it was just one line. So what this new statute does is to look at the experience of CBN, especially the financial crisis we faced in 2008 when we had the Sanusi tsunami, and he stormed the market in a big way. And so there were constraints to what CBN could do then, and the statute seeks to make sure that CBN now is able to exercise what it calls bail-in powers to step in to stem the tide of loss. Second thing, section 34, asset separation tool, by which it's able to separate good assets from bad assets, again drawing from experience of what Chief Idigbe does very well, which is litigate these kinds of problems. The fourth is the sale of business tool, that's section 24. And then very important, how does CBN fund these things? How does CBN ensure that the bank is kept afloat? How does it show that the failing bank doesn't fail? That's in section 74 to 94 of the statute. And then most important, and this I'm sure is going to be the delight of Idigbe and Dr. Ajibade, as these are great gladiators on the courts, as to the creation of a credit tribunal, section 102 to 129. And this is probably the the most revolutionary thing that this statute does. It seeks to create new jurisdiction in this new tribunal to deal with banking problems. I am sure lawyers are going to challenge this provision of the statute. There's going to be interesting points as to the powers of this tribunal, its jurisdiction, and so on and so forth. So these are the key things that we find in relation to preventing banking failures. And I think it's important to note that the statute is deliberate in providing in section 36 for the cooperation of other relevant agencies of government where there's a systemic risk. Experience when it's coming in. What should NDIC do? What should SEC do? What should CAC do? What should the police do? What should NICOM do? Because as we know, a number of banks tend to have tentacles, especially now that you have holdcos and you have banking groups that straddle the financial system. There are different thresholds on non-performing loans. I don't want to get into that, but there are clear provisions on when CBN can provide liquidity support to banks. Moving quickly on, because I like to respect the time I have. I see I have just 4 more minutes. Is the trigger of failure resolution, which is in section 34 of the Act. And this is, as was largely before, upon special examination conducted by CBN that shows that the bank is in a grave situation, section 33(1) of BOFIA, and then where a bank itself notifies CBN of its position, then it can act. There's nothing new in this. This was as before. And then what is new? Not entirely new are the powers of the governor to issue orders, but it's just now clearer. CBN governor can restrict further grant of credit facilities. That was not new. It can ask for suspension of payments and delivery obligations. It can order continuation of service provider contracts. It can order a bank to transfer part of its business. It can order removal of bankers, officers, managers, and directors, notwithstanding the provisions of CAMA or MEMAT. And we've seen, this has been, highly litigated in our courts up to the Court of Appeal. It provides for appointment of advisors. It provides for acquisition of the shares of a falling bank, and it does so in a manner that is a lot more transparent and clearer than what we had, before. Moving quickly on, focusing on sections 37, 38, and 39 of BOFIA, you find that there are underlying principles that deal, and this deals with bailout, on bailing execution. And it's important to note that the absorption of losses by a bank must primarily be borne A, by the shareholders, B, by unsecured and uninsured creditors. And that is a feature that was in section 50 of old BOFIA, but which was a bit confusing to many. And there were questions as to whether this amounted to expropriation. But that is subject for this debate. But in order for banking resolution to be feasible in a manner that doesn't tax the ordinary citizen, is just to begin to apply market discipline. So I'm a shareholder of the bank, I've invested in this, I've been making money in this bank. If there is a loss, as in a partnership, the partners will be the ones that will bear the loss where the business cannot bear it. And you then move to the next set, and Chief Idigbe is the expert on insolvency, and he'll speak to you on the rights of a secured versus an unsecured creditor, and an uninsured versus an insured creditor. And it's clear, as in the evident in the larger market, that the person that bears the brunt of the loss are these people, and the law seeks to provide the depositors. So it's useful to get this man, because there are very many questions as to who should pay for stopping a bank from failing. And this is not really about saving employment, but really about financial system stability. And I think this is very important. There are conditions for billing. I don't want to get into that because that will take time. There are principles underpinning billing. There are things like the ability of CBN to cancel eligible instruments issued by a bank, to modify, in other words, instruments issued by a bank, modify the terms, convert the instruments, change the form of the instruments, and there are penalties of up to 10 million naira or imprisonment not exceeding 6 months for non-compliance with these things. And as I said, there will be questions later. I leave that to the experts on whether billing amount to expropriation. There is a view that it is not, and that billing represents no more than rights and choices in action, which these other people have, that have become worthless, or are soon to become worthless, and therefore there's really nothing to complain about. Let me round up quickly by talking about appropriate separation tool, which is set out in section 41, I believe, of BOFIA. This enables CBN to transfer the assets, the rights and liabilities from a failing bank to a private asset management vehicle. And this is in order to maximize the manner in which this can be dealt with. There's the sale of business tool. We can talk about this maybe when, questions and answers. There are a few reported cases that have dealt with some of these provisions. One of them, an appeal decision, affirms the principle that the assets of a bank must be reserved to settle deposit liabilities in priority to all others. I've spoken about the credit tribunal. This seeks to make sure that banking cases move very quickly. So let me end here in order to give my learned colleagues greater opportunity to shed greater light on this very important subject. Ladies and gentlemen, thank you very much for your...
Thank you very, very much, sir, for that quite interesting context setting. It's good to know how the reforms took a more systemic approach, which brings into consideration both the experiences, the domestic experiences in Nigeria, as well as the global experiences that we observed in the world, 2007, 2008 era, and that the reforms that have been introduced also include some of those instruments and technologies that have been deployed or introduced globally. And with this, I will introduce our next speaker, who has been mentioned a few times by Professor Ajayi. Dr. Anthony Idigbe, SAN, is the senior partner at Punuka Attorneys and Solicitors. He has over 3 decades of experience in various areas of law, including privatization, capital markets, mergers and acquisitions, as well as insolvency law, for which he's probably best known more recently. Dr. Idigbe.
Thank you so much, Dr. Ajibola. And I really want to thank Professor Ajayi, Senior Advocate of Nigeria, for the very incisive overview that he has given us of the profile 2020. He basically has done all the work, but I have been asked to speak particularly on the shift in role from the NDIC to the CBN, and basically to interrogate that shift. And in addition to that, I may make a few comments around administrative law issues concerning the new BOFIA. So in terms of the shift, in some writings, a lot of our scholars, academics have pointed out the weakness of the NDIC regime, which is that it is essentially liquidation focused. It always felt that all it needed to do was to close down the bank and then recover the assets of the bank for the depositors. Of course, we all agree that the depositors are primary concern of the government when a bank is distressed. But generally, it is felt that that view is a bit limited because it doesn't take into consideration the other roles that the bank plays in a system. So, for instance, in many systems, the monetary policy of the government is based on the banks. So if the government wants to inject more money into the system, it uses the bank to do that. So by closing down a bank, you actually restrict the ability of the government to facilitate their monetary policy through the banking system. The second major role that banks play is the payment system. Many people don't know, but most of the payment system, if you take the NAPES, for instance, a lot of the technology around payment, the fact that you get your money, you can transfer money easily, etc., is owned by the banks, either jointly or individually. So when a bank actually is liquidated, it affects the entire payment system. It therefore means that liquidation is not a major. It's not a major choice. It's not a good choice. Let's put it for managing financial distress of banks, and that is why there was the shift to bridge banking, and then the shift to bank resolution, which then puts the CBN at the center of bank resolution. I think Professor Ajayi has dealt with a lot of those tools that have been either refreshed or introduced in the new BOFI. However, perhaps it's important to address some issues. He's spoken about a lot of powers that have been given to the CBN governor now, and then the bailout. I think those are good. Again, one of the drivers of the challenge, the move from NDIC to CBN, is the fact that even when there was a temporary move to AMCOM, that the government was funding on, and as he put it rightly, the people were through their tax money funding the business of banking, as it were, or failed banks. And the government wanted to basically find a way to reduce that sort of subsidy, as it were. And then it was felt that giving all these tools to the CBN is the way. Now, I'm not disagreeing with that. In fact, I agree with most of what has been said. The area of disagreement is this, that the focus on the CBN alone as the measure to resolve financial distress of banks is wrong. The truth is that the backbone should be the insolvency system and the bankruptcy system. The normal bankruptcy system should be able to eliminate, for instance, non-performing loans, etc., or give relief to deserving creditors, debtors, under the normal system. And if that system was working, then the pressure on the banks will be less, because they will be able to resolve most of these issues in the normal debtor-creditor system. And it is the failure of that system that is putting pressure on the banking system and then pushing the government to consider AMCOM and to consider what people will call the draconian CBN measures by the new law. And that raises some issues around how do you guarantee due process, for instance, under this a new law. How do you ensure that there's no arbitrariness? For instance, cases where there has been a bank examination by CBN, and then 2 weeks later, there's a second bank examination with a different outcome from the same CBN, and then an administrative decision taken based on the second one, So I think that definitely calls for some role for the court system to ensure that there's due process. The second one is valuation. A lot of determination is being made here, but I can tell you that there have been instances, for instance, where banks were taken over, all the assets were realized, and then there's a surplus. All the debtors have been paid, and there's a surplus. So that says that maybe the decision to take over that bank was wrong in the first place. But also, there's no, how do you evaluate the figures that are being given? So in many other systems, they try to find how that can be done to give confidence to the new regime. So I worry about those issues. And then when you look at some of the suggestions or the newly introduced provisions, like the tribunal that was introduced, again, that was introduced without an understanding of the issue. Look, without a good support, normal creditor system, creditor-debtor resolution system, you can't, by the time it gets to a tribunal, the situation is already bad. It's already insolvent. The avenue for intervention to restructure the company is already lost. So those, whether you have AMCOM tribunal or you have tribunal under BOFI, it doesn't resolve the support which you really need, which is the general creditor law that is solid and is based on good insolvency principles. And of course, that's why it may be eventually they may set up the tribunal, but I already know it's not going to be effective. It can't solve the problem. So I would like to lay the issues, just a big overview of some of the issues there, and I would like to welcome discussion on some of these issues. Thank you very much.
The way you raised issues around the intersection between the insolvency system and the bank resolution system, and also I think following up on the on one of the themes that Professor Ajayi raised, which was that of the collaboration between key regulators in the space, the CBN and all other, well, I suppose not all of them are regulators, all other agencies that operate in that space. That has been, I would say, one of the more challenging aspects of the regulatory space in Nigeria, where you have several interagency competition without a clear allocation of powers, or where you see some agencies or some regulators take on arrogate too much powers to themselves. So it's really great to hear you start to have that discussion, and I hope that we get many questions along this line to really unpack some of the issues. Well, we move on to our next speaker. Our next speaker is Dr. Babatunde Ajibade, SAN, who is the managing partner of SPA Ajibade & Co. He has substantial expertise in various aspects of commercial litigation and dispute resolution, especially in company law, insolvency law, energy law, labor law, hospitality law, construction law, investment treaty law, and other aspects of commercial law. Dr. Ajibade, please.
Thank you very much, Bolanle. And thank you to the organizers for inviting me to participate in this important discussion. And thank you to my learned seniors, as we say in the profession, Professor Ajayi and Chief Idigbe, for setting out the the ground rules or the groundwork and the big picture of what BOFIA 2020 has sought to do in such erudite manner. The aspect of the topic that I've been asked to speak to is the practical implications, if any, of the newly enacted BOFIA on the capital markets. And I like the way the question was couched. I mean, the if any, it appears that there was some doubt as to whether the BOFIA 2020 has any implications for the capital markets. But I have no doubt in my mind that it does. I think it has practical implications for the capital markets in more ways than one. And I'll just identify a few. And I'll also speak to one or two of the points that Chief Idigbe has made in relation to the administrative law issues that may arise from the extensive powers that have now been given to the CBN, and also the problem with the tribunal that the BOFIA 2020 seeks to establish. But first and foremost, so does the BOFIA 2020 have any implications for the capital market? It definitely does. Banks in Nigeria play a significant role as financial intermediaries and operators in the capital market. So the enhanced regulatory environment that BOFIA 2020 seeks to put in place has an indirect benefit for the Nigerian capital market. And second, and perhaps equally important, is the fact that the banking sector itself constitutes a significant chunk of the Nigerian capital market. So if the increased confidence that will come from enhanced regulation of the banking sector trickles down, it will be of benefit to the Nigerian capital market. And I dare say that I think that it has been of benefit thus far. And a third and closely related point, a reference has already been made to the meltdown, the economic shocks that we had in 2007. I think Professor Ajayi made reference to it, 2007, 2008, 2009. A significant proportion of that distress in the Nigerian capital market resulted from the banks and the distress that happened in the banking sector. Some investors who suffered significant losses in that period are still yet to recover. And I think that if BOFIA 2020, the increased regulatory scope that has been given under the Act, if it serves its purpose, then it cannot but restore confidence in the capital market. One other interesting introduction of BOFIA 2020, which I think has tangential and beneficial effects for the capital market, is the increase in the scope. Section 69 now captures fintechs and provides for their licensing and extends the scope of the CBN's supervisory mandate. And I think that this is a positive, potentially for the capital market. Better supervision of fintechs and the new operators in that space will increase the chances of creating new unicorns that hopefully in due course will seek listing on the Nigerian capital market, thereby deepening the market. So these are the positive sides of BOFIA 2020, where the capital market is concerned. But as has already been highlighted by those who have spoken before me, it is not without its challenges. And I think the first and most important challenge is the one that Chief Idigbe has highlighted. BOFIA 2020 concentrates a significant amount of power in the CBN, and also does not appear to provide sufficient safeguards to ensure that that power is not arbitrarily exercised, and appears also, even where perhaps the power is arbitrarily exercised, appears to impose restrictions on the ability of those who are subject to such arbitrary exercises of power to challenge those exercises. And this is clearly probably for good reason. As Professor Ajayi has said, some of the provisions in BOFIA 2020 are grounded in experiences of what happened in the past, and where the exercise of regulatory power was perhaps too easily challenged, where it was exercised arguably appropriately. The question is how to strike a balance, between not permitting the subjects of regulation to frustrate regulation by easy access to challenge procedures, and on the other hand, how to ensure that the extensive regulatory powers that are granted are not exercised arbitrarily in such a way that would lead to also to market disruption. I think this is something that will require caution and maturity in the manner in which the CBN exercises those powers. I don't think that there's any other solution to that other than to anticipate and hope that the CBN, in exercising those powers, will wield them with the level of discretion that one would expect of a regulator granted such extensive powers as have been granted under BOFIA 2020. The jury is out. I know that within the past year or slightly more than a year, there have been some instances in which the CBN has exercised this power in manners that have given some cause for concern. And the hope is that will be the exception rather than the rule. I think it's important to say that a clear line needs to be drawn between supervision and meddling in the affairs of the regulated entities. So, for example, the provision of BOFIA 2020, which authorizes the CBN examiners to sit as observers at board and committee meetings of banks, is something that I consider to be quite an intrusive corporate governance monitoring tool. The CBN already has quite detailed corporate governance provisions in its code of corporate governance for the banking industry, which is supposed to provide a balanced and relatively independent board for banks that are regulated by the CBN. So to add that the CBN can appoint observers to sit at bank board meetings appears to me to be possible overkill. And one other area which I think has already been mentioned, and I think Dr. Ajibole mentioned it also in her comments just now before while she was introducing me, is the area of coordination. The inadequacy of the coordination between regulators in the financial sector in Nigeria has been a long-standing problem. And BOFIA 2020, in my view, has not done much to address that challenge. The CBN in 1994 undertook to facilitate a formal framework for this coordination by establishing the Financial Services Coordinating Committee, the FSCC, which was subsequently renamed the Financial Services Regulation Coordinating Committee. And this was accorded legal status in the 1998 amendment to the CBN Act. But there's very little information and very little evidence in the sector, that committee is serving the purpose for which it was set up. And I would have thought that BOFIA 2020 would add some clarity to that space, but it has not done so. On the contrary, what I see in section 29 of BOFIA 2020 is the emphasis on the CBN's role as the exclusive regulator for the financial sector, and the conferment of clear powers on the CBN to elbow out any other regulator who might have a contrary view. So the emphasis is not so much on the coordination. The emphasis is on superimposing the CBN on every other regulator in the space. And as even though Section 36 speaks about cooperation between the agencies in times of crisis, as Professor Ajayi has pointed out, I think that, again, as Chief Idigbe has mentioned, I think coordination in times of crisis means shutting the stable door after the horse has bolted. I think it would have been better for BOFIA to provide clearer details and clearer definition of the type of coordination that is expected to take place between the regulatory agencies, albeit even if it is considered that CBN will be the primus inter pares between the regulatory agencies in the financial sector. I think that is a gap that is still missing, and that there's still a disconnect between the regulatory agencies. And we see it in practice on a daily basis. It manifests in different ways. You have regulatory arbitrage, where operators in the sector can hide between the gaps and end up not being regulated effectively by any of the regulators, because they can argue that you're not the one that should be regulating me, it's somebody else. I think those gaps need to be closed by better coordination. And lastly, the tribunal that has been set up. Again, Chief Idigbe has mentioned the fact that the tribunal it doesn't solve the problem, because by the time you get to the tribunal, you already have a problem on your hands. But over and above that, and this is something that he and I have crossed swords on in the past. Over and above that, my challenge with the establishment of tribunals such as that which the BOFIA seeks to set up is that we are running away from a problem and potentially creating new ones. If our justice sector and our regular courts were working efficiently, there will be absolutely no need for setting up a tribunal. At best, maybe you set up a division of the high courts or a division of the federal high court to deal with banking matters and to deal with them expeditiously. Creating a tribunal with jurisdiction that arguably conflicts with the jurisdiction conferred on the superior courts by the Constitution is definitely not going to get us very far. And as Chief Idigbe has said, I'm not surprised that the tribunal is yet to take off in any meaningful manner. I think that the process of legislating these tribunals into being has to be revisited so that we don't have this attempts to resolve challenges with adjudicatory processes repeatedly being done in a manner that doesn't solve the problems that they purport to be set out to do. So in a nutshell, I definitely think that the BOFIA 2020 has practical implications and largely positive implications for the Nigerian capital market, to the extent that the increased regulatory powers given to the CBN, if properly exercised, will improve and increase the confidence in the Nigerian capital market. And given the fact that Nigerian banks themselves constitute a significant chunk of the capital market on both sides, both as operators, intermediaries, and as listed entities, I think that the impact is largely positive. Thank you very much.
Thank you very much, Dr. Ajibade. That was really interesting. And it was great to hear about, well, some of the challenges that we have on the domestic level. It is important that the Nigerian experience is also brought into the international space, particularly because we have several countries that could also learn from us. In Abuja earlier this year, we had people from Ghana, people from Uganda, and I remember that one of the papers was looking at AMCON's role and from a Ghanaian perspective. And it's great to hear you unpack the accountability and coordination challenges that we've had for a while now, and some of the changes that have been introduced and some of the areas that have been missed, and with the hope that we carry on these conversations and perhaps towards the next round of reforms, we would have maybe something that speaks to that more effectively. With that, we move on to our next speaker. Next speaker is Dr. Ajibola Asolo, who is a member of the Aluko and Oyebode capital markets and mergers and acquisition practices, with experience in the regulation of banks, capital market operators, derivative markets, and financial market infrastructures. Ajibola.
Yeah, good afternoon, everyone. Many thanks, Dr. Ajibade and Dr. Adeyemo. Thank you for inviting me to add my voice to this very important conversation. And many thanks to my seniors, Professor Ajayi, Idigbe, and Dr. Ajibade, who've so effectively set the scene as to what we're going to be talking about here. And so I've been invited to speak to the issue of CCPs and TCP resolution in Nigeria. And just before I do that, let me just quickly confirm that participants can see my slides.
We can.
Yes, we can.
Yeah. Brilliant, thanks. So just diving into it. So CCPs are a relatively new contraption within the financial system in Nigeria, and the phrase itself stands for Central Clearing Counterparty. The CCP is an entity that interposes itself between financial market counterparties, known as clearing members, typically DMBs, i.e. deposit money banks. They interpose themselves between transactions or contracts that are traded in one or more financial markets. When this happens, it's used by a process known as innovation. And when this happens, they become the buyer to every seller and the seller to every buyer, thereby ensuring performance of open financial market contracts. As indicated earlier, they're relatively new in the financial system in Nigeria. There are two at the moment. There's FMDQ Clear Limited and NG Clearing Limited. They gained prominence in 2008 after the failure of Bear Stearns, Lehman Brothers, and Ajayi. And what's notable about this circumstance was that when Lehman filed for bankruptcy in 2008, they were a major party to a major player in the global derivatives market, and the portfolio included about 9,000 derivative transactions, estimated at initial value of about circa $35 trillion. Impactful sizes here. And what was interesting here was that it quickly became apparent to everyone that settling bilateral transactions between financial market participants was more cumbersome than settling transactions that are entered into via exchanges and cleared through CCPs. Therefore, 2009, the G20 decided that financial market transactions, particularly OTC derivative transactions, should be traded through exchanges and cleared through CCP. So it's this move that is responsible for the development and advent of these institutions in our financial markets now. So how does the CCP work and what is clearing? So essentially, clearing denotes all activities that take place from the time a financial market transaction is consummated to settlement. So everything that happens in between is referred to as clearing. So everything from entering trades onto the system, trade capture, matching and confirmation, position netting, obligation calculation for counterparties, and everything just before settlement. It's sometimes regarded or referred to imprecisely as settlement, but they're actually two different things. So what typically happens, if you can see this, if you can see my screen at the moment, what happens, is that you can see three figures on my screen right now. And typically what would happen is that in the third figure where you've got the CCP in the middle, you can see essentially what happens is it essentially acts as a clearing system of sorts and nutters the risks that are involved in these transactions. So it stands in the middle, all the transactions becoming the buyer to every seller and the seller to every buyer. So that's the way it works. There are merits and demerits, but I will talk about these very quickly. The first thing is that CCPs help to effect payment netting as between financial market institutions. Therefore, it makes markets more efficient, as we saw in the previous slide. In bilateral transactions, you would have a web of transactions between financial markets participants, between the banks, and these risks. You can quickly imagine how these risks can carry on into another institution where there's a stress scenario. Second advantage is that it helps guarantee future payments and future exchanges of payments between market participants. And thirdly, it helps reduce counterparty risks, liquidity risks, and systemic risks. The notion of systemic risk was something that was alluded to by Professor Ajayi and Chief Idigbe. So CCPs help in this regard. They also help clearing members, they help create exit positions for transactions in financial markets. It also helps enhance regulatory transparency as CCPs report to financial market regulators in Nigeria. They report to the SEC. And finally, because once you have a clearing system in the middle of financial market transactions, it helps to enhance price discovery. You then have a deeper, diverse, and a more liquid market. There are some demerits, and I think that might have been quickly apparent once I started talking. But the first is standard. It relates to what happens when a clearing member of the CCP defaults. Clearing members are, as I said earlier, deposit money banks regulated by the CBN, who are members of the clearing house. So the question as to what happens when they default and how to manage that process, netting inefficiency and high costs are demeriting the system. There's also the issue of interoperability. As I mentioned earlier, there are two CCPs in Nigeria at the moment. Given that financial market institutions would be clearing members on both entities, the question as to how you can, in effect, straddle the financial market transactions across both financial market infrastructures is something that the financial system will need to grapple with. The second bucket of issues pertain to things like default of an investment counterparty. So the capital that the clearing party will have, or the clearing entity will have, will sit with the financial institution. So the question as to what happens if a financial institution runs into trouble, default of a payment bank, and the risks of an extended operational disruption, and of course, simple business risk. But the most crucial demerit that I just emphasize really quickly is the concentration of counterparty credit risk. As I mentioned, CCPs help collect counterparty risks across the financial markets. All the risk, in effect, sits in one place. So the question then becomes, or the issue then becomes, what happens if that CCP runs into trouble? And at the risk of pointing out the flaws in the buffer, this is one of the things that was missed out here, because if something happens with a CCP right now, it's something that we're not really thinking about, but it can happen. And it has happened in the world. So the issue as to the resolution of the CCP is I guess the heart here. Chief Idigbe alluded to a bunch of tools and powers that the financial market regulator, particularly CBN, has when a bank is being resolved. Similar powers exist in other markets to resolve CCPs. at the moment, there's been that is a fracture in our framework, and that is something that we're going to think about in reviewing these laws in the future. But something does exist. There is language that is currently contained in the SEC, CCP, and derivatives rules, which were issued in 2019. And I lay before you, five major prongs of this framework. And conceptually speaking, it does comport with principle 3 of the ISO principles of financial market infrastructures, which provides that a CCP should identify scenarios that potentially prevent it from being able to provide critical operations in a stress scenario. There is reference, that there is some fleeting reference to what happened in a stress scenario in Section 54 of the BOFIA, but as I indicated, it clearly needs to be expanded. There's quite a bit to unpack here, but I expect to unpack in the answer and question session. With that being said, I think that brings me to the end of the slides. And again, thank you, Dr. Ajibola and Dr. Adeyemo, for inviting me to add my voice to a very important conversation. Thank you.
Well, thank you very much, Dr. Asolo, for that presentation. I think that if one thinks about clearing, one just has to think right now about what's going on in the Nigerian aviation industry and the remittance of certain monies. That's where clearing goes wrong. That's one of the challenges that you have, and the effects that it has on an entire industry, and not just the industry, but an entire nation. And I would use the expression that you used in BOFIA. You said there was a fleeting reference to clearing and the resolution of the challenges that might arise in that area. I think that you'd find in the insolvency system as well that there was a fleeting reference to netting provisions, and it's very short, and that's all that was said on netting in that area. And that, of course, brings to mind the links that other panelists have made with the insolvency system, particularly Dr. Idigbe, where he talked about the effective operations of the insolvency system, the main insolvency systems, how that might better assist the effective administration of the banking and financial regulatory system. So thank you very much for that contribution. And I think that we can move on to the question and answer session now. I just want to start with what, for me, is the one of the most interesting areas, and that's because I'm quite interested in coordinating regulators and agencies. It appears that, would it be a fair reading? So this question is to all the panelists. Would it be a fair reading that there's an over concentration of powers with the CBN? And if that is so, given the Nigerian context and the way that those that are regulated and other stakeholders can also fight back, use the system to fight back in quite innovative ways. Does this concentration of powers in the CBN, is it, let's put it this way, what challenges does it portend, and how do you think those challenges can be checked, given the other challenge of the way that the regulated also act in Nigeria? So if I could start with perhaps Dr. Idigbe, and then maybe Dr. Ajibade and Professor Ajayi.
Thank you. Thank you so much, Dr. Ajibola, and thank you for that question. I honestly have found this webinar very enriching. Just to address the question, I think in every system, it's not peculiar to Nigeria. Once you give people power, power can always corrupt. And if you give them absolute power, it can corrupt absolutely. So every system has a design where they put some basic values that are to be pursued, usually in a constitutional document. And that document then guides how everybody else behaves and how we hold government accountable. So I think that there are roles that will be internal, as Dr. Ajibade has said. That is that recruitment at CBN, the quality of people there, their training, etc., to ensure that they pursue the right objective of the law is important. And I think Dr. Ajibade has dealt with that. But outside the CBN, then the rest of the society has to be vigilant. And that is where lawyers have a role to play. Both the lawyers who support the CBN, and I've tried to explain that I am in full support of the basic objective of the law, which is to ensure that there's minimum disruption and you don't have systemic failures. To ensure that they don't use my money to pay for the recklessness of others. In other words, they don't use taxpayers' money to pay for the recklessness of others. But within that context, there's a minefield where these powers can be abused. And therefore, we as lawyers have a role to play, whether we are acting in support of the regulators or whether we are acting in support of those who become victim or subject of that regulation. So, and that again brings into play the issue of access to justice. We must be able to have access to the court system. There must be some, when I advise today on statutory frameworks, I also try to advise the agencies to prevent even going to court, right? Make it unnecessary to go to court by having internal processes. So if you look at some of the ones that the advice, when I used to advise BP, some of the laws that came out, you would see that they would have provisions for rehearing, internal provisions for complaint, etc. I don't really see all that in this particular frame, so that you don't actually have to go to court, because at times there may be cases. And again, I have problems with our court system. But with my experience in Canada, the courts try to defer a lot to administrative institutions. So for instance, even when they find that there has been a fault, they will refer it back to the administrative institution to take a decision, and then maybe to set up a new panel to look at it. The court will not now assume jurisdiction to now decide it as if they are the experts, right? When you have already, budgeted money in National Assembly to have a specialist institution that's supposed to have the experts. Again, that may be a reaction from the fact of lack of confidence in the system. So there are lots of things that we need to do both internally and externally to meet those challenges and then achieve the objective of the law. Thank you.
Okay, thank you. Dr. Ajibade, you're up next, but let me slightly modify that. So could I infer from what you had said, about the way that the powers have been concentrated in the CBN, and also the way that these systems have been created, that there is also a proliferation of these administrative tribunals, which might be for you a challenge, because that would put you on the other side of the table from Dr. Idigbe here. So could you answer the first prong of the question, which is whether, what challenges this over concentration of powers in the CBN can bring, and also whether you are agreed with this proliferation of administrative tribunals that exist.
Thank you, Bolale. So taking the first question, the absence of coordination, I don't think that there's any problem with the CBN, and I think I mentioned that with the CBN, at least as far as the financial sector is concerned, being seen as the primus inter pares. There has to be somebody, leading the pack. What I find to be lacking is any clear structure for how the coordination between the regulatory agencies is supposed to work. And I gave the example of the fact that the CBN itself, I think it was in 1994, was the one that informally set up this financial sector regulatory coordinating committee, which was given some formal backing in 1998. But up till now, I mean, in just doing some desktop research, preparing for this, I tried to find some more information about the FSRCC. The website is not functional. We don't know, are there any guidelines? Do they have to meet at regular intervals? Who is invited to the meeting? What decisions have to be taken along? I mean, this is something that has been a pet peeve of mine for a while. When we had, and I think Professor Ajayi made reference to this earlier as well, when we had the Sanusi tsunami back in the day, one of the things that concerned me is the fact that some of the steps that were taken by the CBN then as the banking regulator, well-intended and seismic shifts in the sector, but there was nothing to show that they were taken with a thought to how it would impact on other sectors of the economy, and that all the other players were carried along, all the other regulators, to say, look, this is what we're going to do. It might impact the capital market in this way. It might impact the insurance sector in this way. So let us all take positions so that we can anticipate the fallout and be prepared to cope with it. So I think it's not so much the concentration of power for me in the hands of the CBN, but it's the absence of any clear structure as to how coordination between the necessarily multiple regulators in the sector will be carried out. In some jurisdictions, they actually just have one super regulator who regulates everything. I wouldn't advocate that. I think concentrating, that would make the situation even worse. So I think it is okay to have separate regulators for different aspects of the financial sector. But I think that the coordination between those regulators needs to be better structured and regulated in itself, so that it is not arbitrary and it's not a situation like we have in the BOFIA. What BOFIA has just done is basically to say that, well, CBN is the boss. So, CBN can choose to carry you along, and when there's a crisis, you must comply with CBN. I'm not sure that that is the best way to go about financial sector regulatory coordination. Now, speaking to the question of the tribunals, again, I don't think that there's any problem with having administrative tribunals. It is the fact that they are being put in place without being well thought through. And as I said, Chief Idigbe and we still have an ongoing battle in court about the Investment and Securities Tribunal, which was, it was well intended. It was well intended that you should set up a tribunal to deal with capital market issues because the courts were not dealing with these matters in sufficient time. But then the establishment of the tribunal, in my view, was not well thought through, because you have subsisting constitutional provisions that create a conflict between the jurisdiction you purport to confer on that tribunal and the jurisdiction already conferred on the courts. So you're just creating more. We still have cases, even though the Federal High Court was set up in 1970, whatever, we still have cases going all the way to the Supreme Court about whether the cases should be in the Federal High Court or the High Court. Now, creating these additional tribunals without clarity as to how they're going to situate or sit within the existing judicial architecture of the country, it is a complete waste of time. We're just compounding issues because, people who have bad cases, and you can't blame lawyers for seizing at, if you create a loophole, a good lawyer who's supposed to do the best for his client will seize it. So if you create these tribunals without the proper groundwork having been done to situate it properly within the framework of the adjudicatory system, you are compounding the problem rather than solving it. And one way of thinking about that also is that rather than creating tribunals, let's strengthen our courts. Where there's a need, where we know that the judges perhaps might not have the necessary expertise in all the rules of the superior courts, you already have provisions for judges to sit with referees or to bring people in with the necessary expertise to support them. I think we would do ourselves a lot of good if we strengthen those provisions strengthen the court system rather than, having, because right now everybody wants to have a tribunal. The EFCC wants a special tribunal. The insurance sector wants a special tribunal. The banking sector wants a special tribunal. Then what do we have the commercial courts for if everybody's going to go to a tribunal? So that's my view.
Thank you very much. Professor Ajayi, I wonder if you wanted to weigh in on the matter being discussed, which is the concentration of powers at the CBN, and whether that portends any challenges for the banking sector. I think that Dr. Ajibade has also introduced the effects of the creation of tribunals on the development of the jurisprudence in Nigeria. And I think that Professor Ajayi touched upon, some of the cases, and, do you see that there is a problem here, or, is everything going well?
Oh, thank you very much. I'm going to be very brief. And let me start where Dr. Ajibade ended, because there he's drawn swords with Dr. Idigbe, all the way from Canada. And, he is fighting from the West Indies. So they're both, in the Western Hemisphere. Don't mind him, he's a West Indian. No, he's from the West Indies anyway. So, but the point is, fortunately or unfortunately, the Supreme Court of Nigeria this year decided in Spectral Oil and Gas Limited and Olaniwun, on whether a body like the IST is constitutional. And rather fortunately or unfortunately, it says it is. So, Dr. Ajibade ready to get the Supreme Court to have a full panel to review its position on this. And, in cases like Ajayi and AP, Odili and Co had decided this point. So, and a few other cases have, considered, other tribunals. And you see, Dr. Ajibade again is an English lawyer, and he hasn't queried the setting up of employment tribunals in England, but he's fighting Dr. Idigbe on ISC, because ISC is Dr. Idigbe's baby. But, jokes aside, the point is that this has come, has been before the Supreme Court. And I'm not sure I would say that, it's not well thought out, because I think you need to look at it again. Now, there are larger questions as to whether the thing to do is to set up a tribunal or to overhaul the High Court altogether. And, there would be a question of capital efficiency and, how you're able to reform the Superior Courts of Record. So, that's a philosophical debate, and I'm just going to leave it at that. Coming to the other point, yes, the body was set up in 1994, and actually they do meet, and they do have rules. So, for instance, if you're dismissed by an insurance company, you will not be employed by a bank or a stockbroker. If you're dismissed by, a merchant bank, you're not going to be employed by anyone in the financial services system. So first of all, they have a database, and so they cooperate. The second thing is that, yes, for everybody there must be a chairman, and CBN happens to be the chair of this body, houses it and hosts its meetings. And they actually have cooperated every time there's been a financial system problem and there's been a need for intervention. So when the banks are going to be taken over in 2009, it was a coordinated approach by NDIC and SEC and CAC and CBN and NICON, because at that time you had universal banks, and the banks, were working on all this. Now, if you look, for instance, at the regulations that have been issued by the SEC, on holdcos, it considers what CBN has done in relation to holdcos. And if you look at what CBN has done, it has a carve-out for SEC does. So they do meet, they do speak. Do they operate as efficiently? No. Can they operate better? Certainly. So there is cooperation, and the suggestion that if they cooperate when there is a problem, it's too late. No. There would always be problems in society. And when there is a problem, it's like our body. We're going to fall ill, whether we like it or not. Yeah, we have doctors that take prophylactic measures, and that's why you have risk-based banking regulation, and you have things as to capital adequacy, and all kinds of ratios that are imposed on banks, and all kinds of regulations and governance standards in order to try and ensure that there's good behavior. But there would always be bad behavior, or at times the market moves against people. Now, so has intervention been beneficial, and has CBN thought of others? Yes. So in 2009, this is what happened. The banks were at that time, the largest part of the capital market. And there was a lot of trade in banking shares. The banks were failing and was pulling down the whole capital market. Secondly, the banks were very big on securities lending or margin lending, and therefore they were providing a lot of loans to people to rush into the capital market. Those loans failed and pulled down the banks. When they pulled down the banks, they pulled down the value, pulled down the stock exchange as a whole, and affected the people. Third, the banks were putting a lot of money in real estate and had built up a lot of estates. World collapsed, capital market, real estate market collapsed, and prices, started to fall because the banks had too large a stock. And Chief Idigbe was making a lot of money, at that time, as he still does, on insolvency. So I'm always jealous of this man. And so you had that. So what did CBN do? And what was the resolution about? The resolution at that time was, what do we do to control the markets and stop, for instance, the constant delivery of stocks onto the stock market, which feeds a downward trend? Come in AMCON. AMCON takes over all the shares and holds them. So there's no more supply of excess stock to the market, and the stock market started to rise. Dr. Ajayi is on the line. I'm sure he's done research on these things. Same thing with real estate market. AMCON came and collected all these real assets and held them, and therefore stock of those assets, was limited. And then, you start to reflate the economy. So these things do have an impact, and these things are actually thought through. This one good thing is that CBN is, if you go in, you begin to see it's one of the best run institutions in the country. Yes, it does abuse power, but just looking at the setup, the offices, the staff, and the capacity they have, you see that they think through a number of these things. Let's limit to this because I know, there may be other questions. Thank you.
Thank you very much, sir. Dr. Ajibade, I'm going to afford you a very short response to that, and then I'm going to yield the floor to Fola, who is picking up questions. Chief Idigbe, I see your hand.
Why is it because he's from the West Indies?
No, he has asked. No, they have raised their hand.
No, special request.
No special request. So a very short response from Dr. Ajibade, and then Dr. Idigbe, very short, and then I'll yield the floor to Fola, who has questions.
Very short. Yes. And my it's just a one-liner basically. I mean, Professor Ajayi has made the point that the Supreme Court has now resolved the jurisdictional disputes in relation to the IST. And that's that's a recent decision. The IST was set up in 2007, I think. Yeah, I think it was ISA 2007. So for me, that in itself just underscores the point. The issue is not that whether it has now been resolved, is that it's taken us 7 to 21. It's taken us 14 years to arrive at a landing as to whether the IST actually has, for the Supreme Court to decide the matter. That is inefficient. I think that if we had established the IST in such a manner, or if it had been established in such a manner that its jurisdiction was not arguable, because I still feel that on a literal interpretation of what the law says and what the Constitution says, there's a conflict between its jurisdiction and that of the Federal High Court. So now that the Supreme Court has resolved it 14 years later, great, but we could have avoided that 14 years of litigation.
Okay, I'll let you land there, but if I could just play the devil's advocate, the fact that we think that we have created a system that is unassailable does not prevent people from challenging it. And as we've already talked about before, we live in the Nigerian context, people will challenge anything if they believe, even if it's just to delay. So I don't think that might have prevented anyone from challenging the jurisdiction of the IST in any event, but I'll just leave it there for another day and move on to Dr. Idigbe.
Thank you. Thank you so much. I just would like to respond to one or two issues. I think the first one is that actually the Supreme Court has consistently upheld the jurisdiction of the IST. There's the Ajayi case, which is my case, which was mentioned by Professor Ajayi. There's also the Isweli case, and then the Nospecto case, all that has to do with Ponzi schemes. So, but yet somehow it's not transmitting to the lowest court. There's still this challenge on jurisdiction. And it's not unusual. So I basically agree with the idea by Professor Ajayi that at times we need to review the philosophy, as it were, and look at other systems and see how they do it and see how we can resolve the problem. With respect to the National Industrial Court, they did a constitutional amendment, so there's no argument. Maybe if we did a constitutional amendment, it may be easier. In other systems, like in Canada, what they do have tribunals, human rights tribunal, immigration tribunal, and there are cost efficiencies that Professor Ajayi mentioned that are significant. You see, if you take, let's say, immigration tribunal in Canada, they do like 10,000 cases. How many cases do the courts do? The procedure is not very formal, right? And it's highly technical. So you need administrative tribunals to deal with the large volume. Most of the people can't afford lawyers. They can't afford the formality of a court process, right? So when you're dealing with housing, for instance, housing tribunals, employment tribunals, right? You would find that it's cheaper to have tribunals than to push all this into the court so that the court can deal with the bigger constitutional, commercial issues. So there's a good argument for that. And then what they did, for instance, there is they created what they call divisional courts. Sorry, 1 minute, I'll soon round up on this. And divisional courts is where instead of going to Court of Appeal, they will have 3 panel judges that will be made up of, let's say, a Federal High Court judge, a State High Court judge, and then they hear the appeals from the tribunal. So it doesn't really go straight to the Court of Appeal. So I'm open to ideas of how we can resolve the issue. The second issue I would like to talk about is the very apt reference that was made to the hospital or healthcare system as a model. And that is really very apt to this problem. You see, let us take the COVID pandemic. The normal healthcare system depends on a structure of a primary healthcare, a clinic, a general hospital, a specialist hospital that takes care of normal sickness, etc. But when you then have pandemic, it's a special one. You now have lockdown, travel restriction, vaccination mandate, etc. When the pandemic is over, you relax all these things and go back to your normal life. Now, what I'm saying is that the normal life, the normal healthcare system, the normal financial system, the normal system of dealing with creditors and debtors is the normal insolvency system, and we are not looking at it. Our bankruptcy law does not encourage anybody, personal bankruptcy law, does not encourage anybody to go and declare himself a bankrupt. In Nigeria, it gives no relief at all. So people resist it. That's why you have no bankruptcy system where people could have gone and said, oh, I'm owing money, I have this property and that property, I give it to my creditors, let them let me go, right? Or something like that. Of course, there will be provision for investigation for fraud and the rest, right? So if that system was working, you will not need AMCOM to carry all this heavy weight, whether it's of shares or of property. So it's only when there's the tools are only available when there's a pandemic, you see, like COVID pandemic, and then you relax it when it's over, but your system should be strong. So what we should be talking about today is how do we strengthen our normal system of creditor-debtor relationship, insolvency, restructuring, rehabilitation. Thank you.
Thank you very much, Idigbe. Fola, can I pass on to you to pick up questions from the audience? And can I ask the panelists to please keep answers really short so that we can finish before the hour? Thank you.
Thank you so much. Thank you again to all of our speakers. I have a question here, and this is for Dr. Asolo. What are some of the recommendations on how to further improve the framework or implementation of the CCP resolution to better align this with international best global practices that can transform Nigeria to be a globally competitive and attain operational excellence? So if I start with Dr. Asolo, please.
Many thanks, Nicodemo. In answering that question, I think the first thing that I would point to would be that the as I noted earlier, the reference to what you could even refer to as content on CCP resolution in the buffer is fleeting. So the first thing I'll do to start with is to even outline comprehensive content on this in the peremptory laws of the country. And there's a chance to do that at the moment because the Investment and Securities Act is currently under review, and it presents a good opportunity to outline the peremptory provisions as it pertains to CCPs there. So some of these gaps that have been alluded to previously, we can solve them there. The second point I would point to is, as has been indicated by learned seniors, the regulatory model is fragmented with the CBN occupying some sort of apex position in the broader financial system, if you will. So as it pertains to CCPs, there needs to be some sort of recalibration. At the moment, these entities are licensed by the CBN, but the reality is that in a stress scenario, with these entities sitting on a lot of concentrated risk, it would be to the CBN to actually discharge the rapid prudential reform or action that we need to see in such a circumstance. Therefore, there's going to be to recalibrate that. If we look to somewhere like the UK, the BOE and the FCA do play a role. Therefore, potentially adopt such an approach. Such a framework, we need to have three things to start with. We need to have preventative measures. We need to have early supervisory intervention measures, and finally, there need to be some resolution measures outlined there. Chief Idigbe, when I was talking earlier, spoke about some of the tools and powers that the CBN has in resolving banks. Similar content can be outlined as it pertains to CCPs. So if you look to the Bank of England, for example, they have tools like position allocation tool, loss allocation tool, write down and conversion of financial instruments tool. Professor Ajayi alluded to this earlier as it pertains to banks. There's also sale of business tool. There's a bridge CCP tool and a public equity support tool, in addition to a temporary public ownership tool. There are also extensive resolution powers that the BOE has in the UK. We can create similar tools here as well. Bridge CCP, appointment of a special manager that that take out the board, come in there and manage the process. But I guess the most radical thing I would say here would be clearly documenting a role for both the SEC and the CBN to play when it comes to the resolution of CCP. My proposal would be that we set out, we position the SEC as a market conduct regulator of sorts, while we position the CBN as a prudential regulator of sorts. Those would be my proposals to kind of strengthen that space. But as I say, what I think is most pressing is that we're actually doing to outline content on this very crucial matter in a law somewhere, as we have in other jurisdictions. Currently, it just sits in a fleeting manner in the SEC, CCP, and derivative rules, and I think this is dangerous. Thanks.
Thank you so much. Bolanle, I see your hand is raised.
Yeah, forgive me for abusing my privileges, but I just wanted to add something, in the question to Dr. Asolo. So much of what you talked about have focused on resolution. How about the preventative measures, before the CCP gets to the point that, we start to think of resolving the issues that arise? Would it not be a more secure foundation to put in place a preventative framework so that we are proactively regulating the CCPs before we then get to problems that may arise?
Thanks a lot. That's a very good question. And again, that kind of hits directly on the gaps that exist in our system at the moment. If the CCPs are licensed and regulated by SEC, there are more impactful members are deposit money banks whose positions are, if you will, superintended by the CBN. You have a circumstance where the SEC has limited to no visibility on the financial positions of deposit money banks, and therefore, as you note, they can't take preventative action before things happen. That again speaks to the point that we do need to be more deliberate about this, and we clearly need to outline market conduct rules and prudential rules clearly for the financial market regulators, and everyone play their part. But again, your point speaks to the point of documenting something very quickly. Thanks.
Fantastic, thank you. This is a question for the entire panel. So I'll read the question now and then I will start. In terms of the Basel III Accord vis-a-vis banking regulation in Nigeria, is the CBN doing enough? And can the accord be extended to MFBs? So perhaps if we can start with Dr. Idigbe first and then move to Dr. Ajibade, please.
Thank you so much. Well, my view about the Basel Accord is that we have to be very careful that Professor Ajayi did mention there are actually some carve-outs between the domestic national banks and the international banks. So Basel focuses a lot on cross-border transactions and international banks. And then when it comes to national banks, if you read it very well, it leaves it to the National Resolution Authority to deal with it. So essentially, it's up to the national government to make prescriptions with respect to resolution of banks that are essentially domestic, as it were. And I think Professor Ajayi did point that out, and it's on that basis that the BOFI designates the CBN as the resolution authority, and it is therefore, say, CBN that should offer support to institutions like AMCOM or NDIC, etc., because it is the designated national authority. So it's you can't use under the Basel system, the banks are all classified. So if a bank is not operating cross-border, there are certain rules that don't apply to them, essentially. And I think that we've been very careful in Nigeria, if you look at the framework in BOFI, to ensure that we are dealing with national banks. And then when it's international banks, that those cross-border measures are taken, and then it's decided which particular authority will regulate that bank, usually the bank where it has its head office, or if in insolvency, you call it COMI, cooperating with the other places where it has establishment. It's in short, if you look at the cross-border regulations around insolvency, and you look at the Basel regulations, they mirror each other, and that's why they are accepted from the cross-border. The application of the cross-border insolvency model law does not apply to banks, so that you use the Basel model, which is very similar, but recognizes that the national authority should be allowed to deal with bank distress within their own border. So I think that in very many ways, what we have done, the framework we have, is quite reasonably consistent with Basel. Thank you.
Thank you so much. Just before we come to Dr. Ajibade, if I could just encourage you to give us a very succinct answer. Thank you so much.
Well, I'll give you even more succinct than you requested. You know, as they say in the Supreme Court, having listened to the submissions of my learned brother, Chief Idigbe, I adopt his position as mine. You can't get more succinct than that.
Fantastic. Thank you so much. Dr. Asolo and Prof, I wonder if you'd like to contribute to this. Okay.
Yeah, thank you, Dr. Adeyemo. I do have a thought or two on this, actually. Yeah, I mean, Chief Idigbe has highlighted, said I put a solid prime on this. The CBN did issue rules in September 2021 as it pertains to the Basel III framework. So it now applies to deposit money banks. So I guess the simple answer to that question is yes, CBN is doing a good job in that respect. As to the point on whether or not it should be extended to MFBs, microfinance banks, my response to that would be no. I think it would be disproportionate to extend such such extensive capital requirements to MFBs. They're just not that significant to financial stability in the broader financial system. Therefore, the answer to that would be no. Thanks.
Fantastic. Thank you so much. Prof. Ajayi, I don't know if you're still here with us. If you'd like to share a thought or two.
Yes, I am. I think to save time, let's just move on. I think Dr. Ajibola has pretty much captured the subject.
Fantastic. Thank you so much. And I have another question. This for Dr. Idigbe. What recommendations do you have to enhance the relationship between the CBN and the NDIC to ensure their roles do not clash or are not duplicated?
Thank you. Thank you so much. I think that takes us back to the point that Dr. Ajibade has been making, and Professor Ajayi. I think their roles are different in very many ways, in the sense that NDIC is focused on making sure that depositors enjoy their priority, which is guaranteed by the same BOFIA. And they do it through an insurance scheme for which premiums are paid. They used to have a role they were playing before, which but I guess they still play some supervisory role. There is a potential for conflict because NDIC used to do their own examination, CBN comes and does their own examination. Then you have even CBN doing too many examinations, different teams, you know, depending on position. So I think there are areas where they can harmonize and where they can cooperate. I know that NDIC is a baby of CBN in very many ways in terms of having actually delivered it, gave birth to it. And then in addition, you know, they have composition where they sit on the board, you know. So I think what the problem is really is our interrogating ourselves as to cost-benefit analysis, right? So the role of CBN, of NDIC has diminished in the sense that we all agree today that you don't need to close down a bank just because you want to pay the depositors. It doesn't make sense because the bank plays other roles in the system, right? As I pointed out earlier. So, and the question is, can that role of ensuring that the depositors are paid be tucked into what CBN is doing, in which case you kill NDIC? Or do you still need deposit insurance as a separate entity to just simply manage the money, the premiums, okay, etc.? Then what about the fact that under the new banking tools that we have, when you talk about the bail-in and bailout, there are also other people who are also contributing money, not just the premium that is being paid. There's the money which is contributed by the creditors of the bank, which they can bail in, for instance. So it's not that the money is physically contributed, but that these are investments which they are required to make and then are available to be bailed in case the bank has difficulty. There is also the one which is being contributed under the asset management company framework, the government one, where they say, okay, we can't keep using government money. So why should you have multiplicity of regulators managing all these different funds for the same risk, right? Shouldn't we consolidate it, etc.? So there are more fundamental issues about whether we should further streamline our system. But in terms of the normal cooperation, I think that there are sufficient grounds for them to cooperate, and they are cooperating so far, as we have seen, but we need to ask the deeper questions of structuring, whether the structure is efficient. Thank you.
Fantastic, thank you. And Prof. Ajayi, I wonder if you want to add any final thoughts to that last point on the relationship between the CBN and the NDIC.
Again, just to save time, I think they actually now do have joint inspections, and they also then have alternate years in carrying out examinations. So CBN does examination this year and shares with the NDIC, and NDIC does it the year after and shares. But obviously when there's special examination, CBN goes on its own. So to that extent, there's a lot of cooperation. And I think Dr. Idigbe has put everything well. The only thing he didn't say is that his baby, the capital market, SEC, is also a child of CBN. They had the Capital Issues Committee, which was born out of CBN. So CBN indeed has born a lot of babies that are now in West Indies and Canada.
Thank you so much, sir. So I'm going to end with this final question. And this is for Dr. Ajibade. What recommendations would you give to enable Bofia to have a positive impact on the capital market and to enhance financial stability in the economy?
Thank you, Fola. Well, I think it's captured in what I said earlier about the potential benefits of enhanced regulation for the capital markets. As has been acknowledged, and Professor Ajayi pointed that out as well. Perhaps more so before than now, But even now, the banking sector still constitutes a significant chunk of the Nigerian capital market, both in terms of its intermediary roles and in terms of a significant chunk of the listed entities being banking corporations. So whatever is done to strengthen confidence in the banking sector definitely has a positive impact on the capital markets. And the upshot of everything that I've heard said, and from analyzing both year 2020, is that even though it's not perfect, say the largest room in the world is the room for improvement. There are a lot of things that could be tweaked, but it is definitely a step in the right direction from where we were with both year 1991. So my view is that if we aggregate the areas in which certain deficiencies have been pointed out, and we try to improve on those, we would definitely have done what is required to ensure that the banking sector and the capital market are going in the right direction. So I don't think that there's specifics other than all the various points that have been identified by all the speakers on this panel that I can point out.
Fantastic. Thank you so much. I think with that, we can bring the session to a close.
Let me say something, Doc, before you close on this subject. And that is that, CBN can do a lot more than he's doing to help the capital market. So we have, capital market operators, and the capital market is about mobilization of capital and channelization of capital. And that's what it does in a different way from what the banking system does. But now CBN has a window, a discount window, which is allowed to have under the CBN Act. And certain instruments are allowed to come into that window. Now, if a number of capital market instruments are allowed into that window, it means there will be greater liquidity and depth and competence in the capital market. So that's one thing. Because what it means is that if the instrument can be discounted, then banks will be able to take those instruments on their books as assets. And when the bank thinks it needs money, it can go to CBN for short money, and there's a discount window. You can discount it there. So that's one thing. The second big thing which CBN can do is look at what is done in Malaysia, which is a bridge to what happens in America, which has very large capital market operators. Our capital market operators are just teeny weeny compared to banks. So if CBN allows the banks to provide better money for the larger capital, and obviously it has to work with SECA, is how are we able to build huge capital market operators that can scale the way the banks do. Now, the point is, in the 60s, Now Merchant Bank was Nigerian Acceptances Limited. It was a pure capital market company, bigger than many banks of that time. So, and it was kind of large capital market activities, issuing houses, function, financial intermediary, and underwriter, and stuff like that. So CBN has to, begin to look at how it's going to help the capital market in this regard. So those two things, the operators and instruments. Thank you.
Fantastic. Thank you so much, sir. Just before I round up, there is a question for Dr. Asolo, but I think Bolanle can ask you this offline, but I'll just read it out. Are we creating CCPS that they're too big to fail, thereby making them inefficient from the outset and therefore creating a moral hazard problem? However, I'll let you answer that question offline because we have just reached 4 o'clock. I'd like to thank all of our speakers today. Thank you so much for your time. Thank you for sharing your insights on this very important topic. We will make the recording available to all of the attendees, and an email will be sent out to everyone. Thank you also to Bolanle of the CLRNN. Thank you for hosting such a fantastic session. And with that, I bid everybody good afternoon. Thank you.